Hello, I'm Attorney Dan Marr from the Nashua law firm of Hamblett Kerrigan here in New Hampshire, and I'm going to be talking in this podcast about vendor contracts, business-to-business contracts, and some of the essential terms. We all know we want to make sure we are paying particular attention to what we're getting paid for our services and products, and when we have to pay, when we are getting paid, and if we're receiving those services and products, likewise what we have to pay and when we have to pay it. All of those things are very important to put into a provision, into a contract, but I'm going to talk about some of the other provisions that are equally important for your business. If you're providing a service business where you're providing services on a weekly, monthly basis, and it says the other side says they want to do it for a year, think carefully about having a termination for convenience provision in there and negotiating that, or some other termination for cause provisions. When can you get out of this deal? Is it just because they don't pay and they get some notice on that and that's the only time you can get out of it? Or can you get out of convenience? If you're going on site in that location to the work site of the person you're putting your employees there, you want to think carefully about, well, what if they're treating them poorly? Can you get out of the deal? And can you do it for convenience? And sometimes it might be a negotiated where you give them 30-day notice and you can get out for convenience. You refund any prepaid monies, and that's the way you deal with it. It also gives a nice signal to the other side to be decent to your people, to think about that, because they can't just have them as indentured servitude for 11 months after the first month is the honeymoon, and then they're treating them lousy. They have a risk there, so you want to think about that. Think about attorney's fees. If you don't get paid, how do you enforce this provision? Attorney fee provision for both sides is something that's usually negotiated between business and business. On some situations, I'm a little concerned about that. If there's really a Goliath and a Davy, a giant company and a small company, that the giant company with the attorney fee provision can make claims that are really not that great, but they don't care if they have to write a check to you eventually for your attorney's fees, but it scares you because you don't want to write a check for them. So if it's in a gray area, you may be a little concerned about that, negotiating. Think about dispute resolution. Do you go for arbitration, which is basically outside of the court system where a private professional makes a decision on the case with both sides presenting a little more streamlined than in court? We can talk about that. Jury trials, you want to generally waive those in business cases, in my experience. And also think about the structure of the contract. Do you want to do if you're having an ongoing relationship with them, do you want a master service agreement, which is the normal term MSA? It might be a professional master service agreement, but that's a term that's used a lot in business deals. And then you have statements of work, SOWs, where you for each project you have a separate deal, but these are all the essential terms, like how do you deal with the intellectual property? Generally for intellectual property, if I'm providing services to you, say I'm doing something for rearranging your office to run more efficiently, maybe through billing or whatever else, the customized provisions that I'm providing to you are generally going to be your intellectual property. I can't use that. I created it for you. I get paid to create for you. But my know-how as to how to do that, all the knowledge that I have with that and software that I have for that, that's mine. Or it might be something that I license from somebody else, but that's not going to be the intellectual property of the customer. Think about those type of details in the situation. Think about the limitation of liability as one of the last points that I would raise in this issue. Is limitation of liability is, well, what happens when there's a claimed breach? You're providing services at maybe a low profit margin, but you want to have this development. You don't want the other side to go and make a mountain out of a molehill in situation. You don't want them to claim consequential damages, incidental damages, lost profits. All of those can be limited in an agreement. I try to limit them when my client's the one providing the services. Sometimes the other side may as well do that because they don't want you to say, because you didn't pay me, you created a domino effect and my business went belly up, and therefore I can come after you for that rather than just for the payment. You want to think about those things. Those are things to have a discussion with your attorney and your business partners and then negotiate on that. And I do negotiate those. I generally like to have limitation of liability policy provisions in there. Also, a provision that says you can't have a jury trial, and those types of things limit down the exposure for if there is a breach, but at the same time having an attorney fee provision that allows for that. So all those things are things that are important in a contract. I'm Dan Marr at 6, and I can be reached at 603-883-5501. I've been doing this for 36 years, 28 years in Massachusetts, 36 years in New Hampshire, and I'm happy to talk to you in regards to these things. I negotiate these contracts regularly for my business clients. Check out our website also at nashualaw.com. And if you have any questions in regards to this, if you call us, you can ask specifically for me if you want to, and they'll go through an intake process, but then after that, it will reach me, and I'll be able to respond to your inquiries in regards to any type of contract negotiations that you're thinking about on a business-to-business relationship. Thank you. I look forward to working with you if the opportunity arises.